How the judiciary seems to be, especially the current one, seems to be a problem because of the inconsistency of some of the decisions. For example, you're talking about they came up with the decision that no, you don't have an individual right to vote, but there is an individual right to own guns. I mean, how, the inconsistency of their processes. How is there a way that we can call for a consistency to say, okay, you have these two things, they're opposite to each other, you must reconcile them? Is there a mechanism for doing that?
Let me give you a little kind of interesting thing on here. So do you know that at one time that the Supreme Court was made up of 10 justices? You know how it got down to 9? During the battle over appointment to replace a judge during Reconstruction. Some at that time thought it's better to have 10 because sometimes those two should not be a decision. It should be split, and so things will remain as they are more or less. The reason it got down to 9 is because one of them died, and Andrew Johnson, what they call his ascendancy, because he got president by the accident of the Lincoln being assassinated. He was going to appoint the next Supreme Court justice, and he was the radical Congress at that time, who was interested in black and knew that Andrew Johnson was not protecting black former slaves and their right to vote in former Confederate states. And the judge that he was put forth to be the Attorney General, that he wanted to go to Supreme Court. You know why he was rejected by that Congress? Because he drafted a veto message for the president vetoing the first civil rights bill for the former slaves. They actually rejected. And the Attorney General was of their party. Everyone said he was knowledgeable, but he was morally on the wrong side of history, and they denied him. So Johnson said, okay, well, I'm going to keep putting forth nominees that have the same judicial philosophy. They say, oh yeah? They eliminated the seat. And say, we won't restore the seat to 10 until after Ulysses Grant, but they never got around to restoring it. So that's how we got down to 9. So that was there was an idea at one time. Now, the other thing is you do have a check on the, like I said, every time these 9 unelected officials meet, there is in fact a constitutional convention. We have a constitutional convention technically every year, by judicial determination, and it is the enforcement provision. That's why they put the only constitutional amendments that you'll find that has an enforcement clause is the ones that were passed, what's called the Reconstruction Amendment. And what that says is the legislature has the power by legislation to enforce this Constitution. And so under the 15th Amendment, that's how Supreme Court decisions are overturned. Under the enforcement clause, they say they list the number of Supreme Court decisions and what they decided, and say this is a bunch of crap. This legislation is crafted to address these bogus decisions, and they passed it in the form of what they call an act. That's what the Civil Rights, the 1965 Civil Rights Act was to overturn some bogus decision the Supreme Court made. Now they're talking about legislate. So it's not so much the Congress, it's the legislative will. If you have the legislative will that comes from what you're talking about, what Carl was talking about, power concedes nothing without agitation. And what you're talking about, we need to organize. And that organizing, to some extent has to be focused around the thing is we don't have to play the game that lawyers say. When they use a precedent, we can say that is a racist decision. Yeah, that's a precedent. No one disagreed that in such and such a case you said you made this statement. That was a racist. Are we going to have our modern decision based on that racist decision that was made? Plessy versus Ferguson was not the only racist decision that was made during that time. The Ferguson versus Bracken, U.S. versus Reese, U.S. versus Crumshine. All of these cases, that is the basis of Bush. One of the fallacy of our judicial system is the pretense that it is a science. We as a people, the legislature has, under enforcement clause, a provision under legislature to correct when the Supreme Court goes off the reservation. But we, the people, are the ones, by voting progressive, we have to vote progressive people to be in Congress in order to enforce that part of the Constitution.